Question 1. The efficiency study reveals that a significant portion of the legal team's e-discovery efforts are being hampered by delays in the digital forensics phase. To expedite this process, the team is considering several approaches to data collection and analysis. Which of the following approaches best aligns with the basic principles of digital forensics in e-discovery, ensuring defensibility and integrity of evidence within the CLTP framework? Option A. Utilizing general IT diagnostic tools and techniques for data retrieval, assuming that if the data is accessible to the IT department, it is sufficient for legal purposes. Option B. Prioritizing the rapid collection of the largest possible volume of data using standard file copying methods to ensure all potentially relevant information is captured quickly. Option C. Delegating the entire forensic process to junior IT staff who have basic computer knowledge, with the expectation that they can manage the data collection efficiently. Option D. Employing forensically sound imaging techniques with right blocking, meticulous chain of custody documentation, and systematic analysis of collected data, even if it requires more time. Correct answer is D. Employing forensically sound imaging techniques with right blocking, meticulous chain of custody documentation, and systematic analysis of collected data, even if it requires more time. Explanation. Scenario analysis. This scenario presents a common challenge in legal technology where the rapid pace of technological advancement, particularly in data forensics, outstrips the established understanding and application of e-discovery principles. The pressure to deliver timely and cost-effective results, coupled with the inherent complexity of digital evidence, necessitates a nuanced approach that balances technical proficiency with legal and ethical obligations. The professional challenge lies in ensuring that the forensic process, while aiming for efficiency, does not compromise the integrity, admissibility, or defensibility of the digital evidence, all within the strict confines of the Certified Legal Technology Professional (CLTP) regulatory framework. Correct approach analysis. The correct approach prioritizes the foundational principles of digital forensics as they apply to e-discovery, ensuring that the process is systematic, documented, and defensible. This involves adhering to established forensic methodologies, such as maintaining a strict chain of custody, preserving data integrity through right blocking, and employing forensically sound imaging techniques. The CLTP framework, by its nature, mandates adherence to best practices that ensure the reliability and admissibility of digital evidence. This approach aligns with the core tenets of digital forensics, which are designed to collect and preserve evidence in a manner that is trustworthy and withstands scrutiny in legal proceedings. It emphasizes a methodical and meticulous process, which is crucial for meeting the evidentiary standards required in any legal matter. Incorrect approaches analysis. One incorrect approach focuses solely on speed and volume of data collection, potentially bypassing crucial steps like forensic imaging or right blocking. This directly violates the principle of data integrity, a cornerstone of digital forensics. Failure to preserve data in its original state can lead to accusations of tampering or alteration, rendering the evidence inadmissible and exposing the legal team to professional sanctions for negligence and ethical breaches. Such an approach disregards the CLTP implicit requirement for defensible evidence. Another incorrect approach might involve relying on non-forensic tools or methods for data collection and analysis, such as simple file copying, or using standard IT diagnostic tools. While these might be efficient for routine IT tasks, they do not guarantee the preservation of metadata or the prevention of data alteration, which are critical for forensic soundness. This disregard for specialized forensic techniques undermines the reliability of the evidence and fails to meet the professional standards expected of a CLTP, potentially leading to the exclusion of vital evidence and reputational damage. A third incorrect approach could be to delegate the entire forensic process to individuals without specific digital forensics training or CLTP certification, assuming that general IT knowledge is sufficient. This is a significant ethical and professional failing. Digital forensics requires specialized knowledge and adherence to strict protocols that differ from standard IT practices. Without proper expertise, critical steps can be missed, evidence can be compromised, and the entire e-discovery effort can be jeopardized, leading to legal and professional repercussions. Professional reasoning. Professionals should approach digital forensics in e-discovery by first understanding the specific legal context and the nature of the data in question. They must then select and apply forensically sound methodologies that are documented and repeatable. This involves a continuous assessment of risks to data integrity and admissibility. The decision-making process should always be guided by the CLTP commitment to ethical practice, defensibility, and the pursuit of justice through reliable digital evidence. When faced with efficiency pressures, professionals must advocate for and implement processes that uphold these fundamental principles, rather than compromising them for expediency. Question 2. Implementation of a comprehensive electronic data source impact assessment for a complex litigation matter requires a strategic approach to identify, evaluate, and manage the risks and costs associated with diverse data types. Which of the following approaches best ensures defensible and proportionate discovery? Option A. Prioritize the collection of data from easily accessible sources like standard email servers and document management systems, deferring investigation of cloud storage, social media, and EOT devices until specific evidence is requested. Option B. Adopt a reactive approach, collecting data only when specific evidentiary needs arise during the litigation process, assuming that most dynamic data sources will remain accessible. Option C. Immediately initiate the collection of all data from every identified electronic source to ensure no potentially relevant information is missed, regardless of its perceived relevance or the associated costs. Option D. Conduct a detailed inventory of all potential electronic data sources, including email, documents, databases, social media, cloud storage, mobile devices, and EOT devices, followed by an assessment of their characteristics, potential relevance, and associated risks and costs before defining a targeted collection and processing strategy. The correct answer is D. Conduct a detailed inventory of all potential electronic data sources, including email, documents, databases, social media, cloud storage, mobile devices, and EOT devices, followed by an assessment of their characteristics, potential relevance, and associated risks and costs before defining a targeted collection and processing strategy. Explanation. Scenario analysis. The scenario presents a common challenge in legal technology, integrating diverse electronic data sources into a cohesive and legally defensible discovery process. The sheer volume, variety, and dynamic nature of data from sources like cloud storage, social media, and EOT devices create significant hurdles. Professionals must navigate the technical complexities of data acquisition, preservation, and analysis while adhering to strict legal and ethical obligations. The challenge lies in ensuring that all relevant data is identified, collected, and produced in a manner that is both forensically sound and compliant with discovery rules, without overcollection or spoliation. Correct approach analysis. The correct approach involves a comprehensive, phased impact assessment that begins with a thorough understanding of the data landscape. This includes identifying all potential electronic data sources relevant to the matter, assessing their characteristics e.g., format, volume, accessibility, volatility, and evaluating the associated risks and costs of collection and processing. This systematic approach ensures that legal teams can develop a targeted and proportionate discovery strategy. It aligns with best practices in e-discovery, emphasizing defensibility and efficiency. By prioritizing sources based on their likely relevance and the potential impact of their inclusion or exclusion, legal technology professionals can optimize resource allocation and minimize the risk of noncompliance. This proactive planning is crucial for meeting discovery obligations under relevant legal frameworks, such as the Federal Rules of Civil Procedure in the U.S., which mandate proportionality and relevance in discovery. Incorrect approaches analysis. Focusing solely on easily accessible data sources like standard email and document repositories, while neglecting cloud storage, social media, and EOT devices, represents a significant regulatory and ethical failure. This approach risks incomplete discovery, potentially leading to adverse inferences or sanctions for spoliation of evidence. It fails to acknowledge the evolving landscape of electronic data and the likelihood that critical information resides in less conventional sources. Prioritizing the collection of all data from every identified source without a prior assessment of relevance or proportionality is also professionally unacceptable. This collect-everything approach is inefficient, costly, and increases the risk of producing privileged or irrelevant information, potentially violating privacy regulations and ethical duties to the court. It demonstrates a lack of strategic thinking and a failure to apply the principles of proportionality mandated by discovery rules. Adopting a wait-and-see approach, where data collection is deferred until specific needs arise during litigation, is another critical failure. This reactive stance can lead to data loss or alteration, as dynamic data sources like social media or cloud storage are often ephemeral. It undermines the obligation to preserve potentially relevant evidence as soon as litigation is reasonably anticipated, a fundamental tenet of discovery law. Professional reasoning. Professionals should adopt a risk-based, phased approach to impact assessment for electronic data sources. This involves 1. Early case assessment. Understand the nature of the dispute and identify potential custodians and data sources. 2. Data source identification and characterization. Systematically identify all relevant electronic data sources, including their format, location, volume, and accessibility. 3. Risk and relevance assessment. Evaluate the potential relevance of data from each source and the risks associated with its collection, preservation, and production. 4. Proportionality analysis. Determine the scope of discovery based on the needs of the case, considering factors like the importance of the issues, the amount in controversy, and the party's ability to afford discovery. 5. Defensible collection and processing strategy. Develop a plan for collecting and processing data that is forensically sound, preserves the integrity of the data, and meets legal and ethical requirements. 6. Ongoing review and adaptation. Continuously review the discovery process and adapt the strategy as new information or data sources emerge. This structured decision-making process ensures that legal technology professionals can effectively manage the complexities of e-discovery, uphold their professional responsibilities, and achieve just outcomes. Question 3. The risk matrix shows a high likelihood of data breaches and smart contract vulnerabilities when implementing new blockchain-based solutions for client onboarding and digital identity verification. Considering the UK regulatory framework and CISI guidelines for legal technology professionals, which of the following approaches best mitigates these identified risks while ensuring compliance? Option A. Select a blockchain platform based primarily on its low transaction fees and rapid deployment capabilities, with minimal emphasis on independent security audits or detailed data protection impact assessments. Option B. Prioritize a phased implementation of blockchain technology, starting with a pilot program for internal document management, accompanied by independent smart contract code audits and the establishment of a comprehensive data governance framework aligned with UK GDPR principles. Option C. Implement smart contracts for all client agreements without prior legal review of their code, relying on the assumption that the technology's self-executing nature negates the need for traditional legal oversight. Option D. Immediately deploy a cutting-edge, decentralized identity solution across all client-facing platforms, assuming that the inherent immutability of blockchain will automatically secure all data and resolve potential vulnerabilities. The correct answer is B. Prioritize a phased implementation of blockchain technology, starting with a pilot program for internal document management, accompanied by independent smart contract code audits, and the establishment of a comprehensive data governance framework aligned with UK GDPR principles. Explanation. Scenario analysis. This scenario presents a common challenge in legal technology adoption, balancing the innovative potential of blockchain for smart contracts and digital identity with the inherent risks of data security and regulatory compliance. The professional challenge lies in evaluating different implementation strategies, not just for technical efficacy, but for their adherence to the specific regulatory framework governing legal technology professionals in the designated jurisdiction, assumed to be the UK for this CLTP context, referencing relevant UK laws and CISI guidelines. The need for careful judgment stems from the potential for significant financial, reputational, and legal repercussions if a chosen approach fails to meet these stringent requirements. Correct approach analysis. The correct approach prioritizes a phased, risk-mitigated integration of blockchain technology, focusing on robust data security protocols and clear governance frameworks that align with UK data protection laws, e.g., UK GDPR, and CISI professional conduct rules. This involves conducting thorough due diligence on blockchain platforms, ensuring smart contract code is audited by independent experts, and establishing clear procedures for digital identity verification and management that comply with KYC/AML regulations where applicable. The emphasis on ongoing monitoring and adaptation demonstrates a commitment to maintaining compliance and security in a rapidly evolving technological landscape, reflecting best practice in professional responsibility and risk management. Incorrect approach is analysis. Implementing a blockchain solution without a comprehensive security audit of smart contracts exposes the firm and its clients to significant risks of exploitation, leading to potential financial losses and breaches of client confidentiality, which violates professional duties of care and data protection regulations. Adopting a platform solely based on its perceived cost-effectiveness, without assessing its compliance with UK data residency requirements and data processing agreements, would be a direct contravention of UK GDPR principles. Relying on self-sovereign identity solutions, without establishing clear legal recourse mechanisms or dispute resolution processes for digital identity-related issues, creates a significant legal and ethical vacuum, potentially leaving individuals vulnerable and the firm liable for inadequate client protection. Furthermore, neglecting to integrate robust access controls and audit trails for smart contract execution and data stored on the blockchain would undermine transparency and accountability, failing to meet the standards expected under professional conduct guidelines. Professional reasoning. Legal technology professionals must adopt a systematic, risk-based approach. This involves 1. Understanding the specific regulatory landscape, UK GDPR, relevant financial services regulations, SISI guidelines. 2. Conducting thorough due diligence on all technology components, including smart contract audits and platform security assessments. 3. Developing clear governance policies and procedures for data management, digital identity, and smart contract execution. 4. Prioritizing client protection and data security above all else. 5. Implementing ongoing monitoring and review mechanisms to ensure continued compliance and adapt to emerging threats and regulatory changes. Question 4. Compliance review shows that in a complex commercial litigation matter, the legal technology team, after a Rule 26F conference, drafted a Rule 34 request for ESI that broadly asked for all documents and communications related to the subject matter of this litigation. Subsequently, the opposing party responded with a Rule 34 request seeking all emails, instant messages, and internal memos from the last 5 years that mention any competitor. Which of the following approaches best aligns with the Federal Rules of Civil Procedure and best practices for e-discovery? Option A. The legal technology team should engage in a meet and confer with opposing counsel to refine both requests, focusing on specificity, proportionality, and the agreed-upon scope of discovery from the Rule 26F conference before producing any ESI. Option B. Legal technology team should immediately object to the opposing party's request as overly broad and unduly burdensome, while simultaneously preparing to produce ESI based on their initial broad request, assuming the court will narrow the scope later. Option C. The legal technology team should unilaterally determine that the opposing party's request is unreasonable and limit their own production to only clearly relevant, narrowly defined categories of ESI, without further consultation or negotiation. Option D. The legal technology team should proceed with producing ESI based on their initial broad request, believing that the opposing party's equally broad request validates their approach and that any disputes can be resolved through motions to compel later. The correct answer is B. The legal technology team should immediately object to the opposing party's request as overly broad and unduly burdensome, while simultaneously preparing to produce ESI based on their initial broad request, assuming the court will narrow the scope later. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of the interplay between Federal Rules of Civil Procedure, FRCP, and the practical realities of e-discovery. Specifically, the tension lies in balancing the broad discovery scope permitted by Rule 26 with the specific limitations and proportionality considerations inherent in Rule 34, all while adhering to the sanctions framework of Rule 37. A legal technology professional must navigate these rules to ensure efficient and compliant discovery, avoiding both overproduction and underproduction of electronically stored information. The challenge is amplified by the potential for sanctions if discovery obligations are not met, impacting client costs and case outcomes. Correct approach analysis. The correct approach demonstrates best professional practice by prioritizing a thorough and collaborative approach to defining the scope of discovery. This involves engaging in a detailed Rule 26F conference to identify discoverable ESI, discuss preservation obligation, and propose a discovery plan. It then moves to a precise Rule 34 request that clearly specifies the ESI to be produced, considering proportionality and burden. Finally, it ensures compliance with any court orders or agreements, and proactively addresses potential issues to avoid Rule 37 sanctions. This approach aligns with the FRCP intent to promote efficient and just resolution of disputes by ensuring relevant information is discoverable while preventing undue burden. Incorrect approach is analysis. One incorrect approach fails by making overly broad or vague Rule 34 requests. This is a regulatory failure under FRCP Rule 34, which requires specificity in describing the items to be produced. Such vagueness can lead to disputes, increased costs, and potential sanctions under Rule 37 for failing to properly conduct discovery. It also ignores the proportionality considerations implicitly required by the overall discovery framework. Another incorrect approach is to unilaterally limit the scope of ESI production based on perceived burden, without engaging in the required meet and confer process or seeking a protective order. This violates FRCP Rule 26B, 1, by potentially withholding discoverable information, and FRCP Rule 37, by failing to seek court intervention or agreement on limitations. It also bypasses the collaborative spirit of discovery. A third incorrect approach involves failing to adequately preserve ESI identified during the Rule 26F conference. This is a direct violation of preservation duties, which can lead to severe sanctions under FRCP Rule 37, including adverse inferences or even dismissal of claims. It demonstrates a lack of diligence and a failure to uphold discovery obligations. Professional reasoning. Professionals should approach e-discovery by first understanding the overarching discovery goals outlined in FRCP Rule 26. This includes actively participating in Rule 26F conferences to establish clear parameters for discovery. When drafting or responding to Rule 34 requests, precision and clarity are paramount, ensuring that the scope of ESI sought or produced is well-defined and proportionate to the needs of the case. Proactive communication with opposing counsel and the court is essential to resolve disputes and avoid potential sanctions under Rule 37. A systematic approach that prioritizes compliance, proportionality, and collaboration will best serve the client and the integrity of the legal process. Question 5. The monitoring system demonstrates a continuous stream of user activity logs from a critical server. An urgent request is received from the legal department for immediate access to specific log entries related to a potential compliance breach. The CLTP is tasked with providing this information while ensuring its integrity for potential legal proceedings. Which of the following actions best upholds the chain of custody for this electronic evidence? Option A. Provide the legal department with read-only access to the live server to allow them to review and extract the log entries themselves. Option B. Forward the request to the IT operations team, asking them to retrieve the logs and provide them directly to the legal department without further CLTP involvement. Option C. Directly access and copy the relevant log files from the live server to a separate drive for the legal department, noting the time of access in a personal notebook. Option D. Create a forensically sound image of the server's storage containing the logs, generate a cryptographic hash of the image, and then extract the requested log entries from the verified image, documenting all steps. The correct answer is D. Create a forensically sound image of the server's storage containing the logs, generate a cryptographic hash of the image, and then extract the requested log entries from the verified image, documenting all steps. Explanation. This scenario presents a professional challenge due to the inherent tension between the need for timely access to electronic evidence for ongoing investigations and the absolute requirement to maintain the integrity of that evidence to ensure its admissibility in legal proceedings. The Certified Legal Technology Professional, CLTP, must balance operational demands with stringent evidentiary standards. The correct approach represents best professional practice because it prioritizes the preservation of the chain of custody through a documented, controlled, and verifiable process. This aligns with fundamental legal principles governing the admissibility of electronic evidence, which demand proof that the evidence has not been tampered with or altered since its collection. Specifically, adherence to established protocols for forensic imaging, hashing, and secure storage directly addresses the CLTP ethical and professional obligation to uphold the integrity of the judicial process. This meticulous approach ensures that the evidence remains reliable and defensible, preventing challenges based on potential contamination or alteration. An incorrect approach that involves direct manipulation of the original evidence without proper forensic procedures fails to maintain the chain of custody. This constitutes a significant regulatory and ethical failure because it compromises the integrity of the evidence, rendering it potentially inadmissible. Such actions violate the CLTP duty to act with due diligence and competence, as well as their responsibility to uphold the principles of evidence law. Another incorrect approach, which involves relying solely on the system's automated logs without independent verification or secure handling of the original data, also presents regulatory and ethical issues. While automated logs can be part of the chain of custody, they are not a substitute for the physical or digital preservation of the evidence itself. Failure to secure the original evidence and create forensically sound copies means that the evidence's integrity cannot be independently verified, leading to potential challenges regarding its authenticity and reliability. This demonstrates a lack of understanding of the core requirements for handling digital evidence in a legal context. A third incorrect approach, which involves sharing the original evidence with unauthorized personnel or storing it in an insecure location, represents a severe breach of professional responsibility. This not only jeopardizes the integrity of the evidence, but also violates data privacy and security regulations, potentially leading to legal repercussions for the CLTP and the organization. The ethical failure lies in the disregard for confidentiality and the duty to protect sensitive information. The professional decision-making process for similar situations should involve a thorough understanding of the relevant legal frameworks governing electronic evidence, including rules of evidence and specific statutes. Professionals must prioritize established forensic best practices, such as creating forensically sound images, using cryptographic hashing to verify integrity, and maintaining meticulous, unbroken documentation of all handling and access. When in doubt, consulting with legal counsel or experienced forensic investigators is crucial to ensure compliance and maintain the highest standards of professional conduct. Question 6. Investigation of a complex litigation matter has commenced, requiring the collection and processing of substantial volumes of electronically stored information, ESI, from multiple sources. The ESI is known to contain a significant amount of personal data belonging to individuals involved in the litigation, as well as commercially sensitive proprietary information. The legal team has instructed the Certified Legal Technology Professional, CLTP, to manage the e-discovery process, with a paramount concern for protecting this sensitive information from unauthorized access or disclosure throughout the collection, processing, review, and production stages. Which of the following approaches best adheres to data security and privacy best practices within the CLTP regulatory framework? Option A. Rely on standard password protection for all data transfers and storage, assuming that the network infrastructure is sufficiently secure to prevent unauthorized access. Option B. Transfer all ESI via unencrypted email attachments to external review platforms, as this is the most efficient method for large data volumes. Option C. Conduct a basic risk assessment and then proceed with data collection and processing using the most readily available tools, without specific emphasis on advanced encryption or granular access controls. Option D. Implement end-to-end encryption for all data transfers and storage. Enforce strict role-based access controls with regular audits, and utilize secure, anonymized data handling environments for processing and review where feasible. The correct answer is D. Implement end-to-end encryption for all data transfers and storage, enforce strict role-based access controls with regular audits, and utilize secure, anonymized data handling environments for processing and review where feasible. Explanation. This scenario presents a common challenge in legal technology, balancing the imperative to preserve and produce electronically stored information (ESI) with the stringent requirements of data security and privacy. The professional challenge lies in navigating the complex legal and ethical obligations to protect sensitive client data, particularly personal data, from unauthorized access or disclosure during the e-discovery process, all while adhering to the specific regulatory framework governing the Certified Legal Technology Professional (CLTP) exam. This requires a nuanced understanding of data handling protocols, risk assessment, and the application of appropriate technical and organizational measures. The correct approach represents best professional practice because it prioritizes a comprehensive, risk-based strategy that aligns with the principles of data protection by design and by default, as often mandated by data privacy regulations. Implementing robust encryption, access controls, and secure transfer methods directly addresses the potential for data breaches and unauthorized disclosure. This proactive stance minimizes the risk of violating data privacy laws, maintaining client confidentiality, and upholding professional ethical standards. It demonstrates a commitment to safeguarding sensitive information throughout its lifecycle in the e-discovery process. Each incorrect approach carries significant regulatory and ethical failures. One incorrect approach might involve a blanket assumption that all ESI is equally sensitive and requires the highest level of protection, leading to unnecessary costs and delays without a commensurate increase in actual security. This fails to apply a risk-based approach, which is often a cornerstone of data protection compliance, potentially violating principles of proportionality and efficiency. Another incorrect approach could be to rely solely on basic password protection for data transfer, neglecting more advanced security measures like end-to-end encryption. This would be a direct failure to implement adequate technical and organizational measures to protect personal data, potentially violating specific provisions of data protection legislation that require robust security. A further incorrect approach might be to overlook the need for data minimization or anonymization where appropriate, leading to the unnecessary exposure of sensitive information. This would contravene the principles of data minimization and purpose limitation, increasing the risk of privacy violations and potential regulatory penalties. Professionals should employ a decision-making framework that begins with a thorough understanding of the scope and nature of the ESI involved, identifying any personal or highly sensitive data. This should be followed by a comprehensive risk assessment to determine the potential threats and vulnerabilities associated with handling this data during e-discovery. Based on this assessment, professionals must select and implement appropriate technical and organizational security measures, such as encryption, access controls, audit trails, and secure data transfer protocols, in accordance with relevant legal and ethical obligations. Regular review and updates of these measures are crucial to adapt to evolving threats and regulatory requirements. Question 7. What factors determine the most appropriate e-discovery platform configuration for a UK-based litigation matter, considering the need for defensible data preservation and compliance with the civil procedure rules? Option A. The platform's capacity to convert all documents to a standardized format for ease of review, even if it results in the loss of original metadata. Option B. The platform's ability to preserve original file metadata, maintain a clear chain of custody, and facilitate proportionate review in accordance with UK civil procedure rules and practice directions. Option C. The platform's integration with the client's existing internal document management system, without a specific assessment of its e-discovery compliance features. Option D. The platform's processing speed and the lowest available subscription cost, irrespective of metadata preservation capabilities. The correct answer is B. The platform's ability to preserve original file metadata, maintain a clear chain of custody, and facilitate proportionate review in accordance with UK civil procedure rules and practice directions. Explanation. This scenario presents a professional challenge because the Certified Legal Technology Professional, CLTP, must balance the technical demands of e-discovery with the stringent legal and ethical obligations governing data preservation and production. The core difficulty lies in ensuring that the chosen e-discovery platform and its configuration not only meet the client's immediate needs, but also comply with the relevant regulatory framework, specifically the UK's Civil Procedure Rules (CPR) and associated practice directions, as well as the Solicitor's Regulation Authority (SRA) Code of Conduct. The CLTP must exercise careful judgment to avoid creating discoverable metadata that could be inadvertently altered or lost, or failing to preserve data in a manner that is both defensible and proportionate. The correct approach represents best professional practice because it prioritizes a thorough understanding of the client's specific legal obligations and the technical capabilities of the e-discovery solution in relation to those obligations. This involves a proactive assessment of the platform's ability to preserve original metadata, maintain chain of custody, and facilitate proportionate review, all while adhering to the principles of CPR Part 31 and Practice Direction 31A regarding disclosure. The CLTP role is to ensure that the technology serves the legal process effectively and ethically, minimizing the risk of spoliation or noncompliance. An incorrect approach that focuses solely on the speed of processing without considering metadata preservation would fail to meet the requirements of CPR Part 31, which mandates the disclosure of relevant documents and their associated metadata. This could lead to allegations of spoliation if critical metadata is lost or altered, jeopardizing the integrity of the evidence. Another incorrect approach that prioritizes cost reduction by selecting a platform with limited metadata handling capabilities, without a clear understanding of the potential legal implications, would also be professionally unacceptable. This could violate the SRA Code of Conduct's principles of acting with integrity and in the best interests of the client, as it might expose the client to significant legal risk. A third incorrect approach that neglects to document the chosen e-discovery process and its justification would undermine defensibility and transparency, making it difficult to demonstrate compliance if challenged. The professional decision-making process for similar situations should involve a structured approach. First, clearly define the legal and regulatory requirements for disclosure and data preservation in the specific jurisdiction, UK CPR and PD. Second, assess the technical capabilities of potential e-discovery solutions against these requirements, with a particular focus on metadata handling, chain of custody, and defensibility. Third, conduct a risk assessment, considering the potential consequences of non-compliance or data compromise. Fourth, document all decisions and justifications thoroughly. Finally, seek expert legal advice when necessary to ensure full compliance. Question 8. When evaluating the integration of a new AI-powered legal research and document review platform into a law firm's practice, which of the following represents the most ethically sound and professionally responsible approach for a certified legal technology professional, CLTP? Option A. Prioritize the cost-effectiveness of the AI solution, focusing primarily on its ability to reduce operational expenses with minimal independent technical or ethical review. Option B. Accept the vendor's assurances regarding the AI's performance, security, and compliance with relevant regulations, and proceed with rapid implementation to capitalize on potential efficiency gains. Option C. Conduct a thorough due diligence process, including independent validation of the AI's accuracy and bias mitigation strategies, verification of robust data security and confidentiality protocols, and defining clear parameters for human oversight of AI-generated outputs before recommending adoption. Option D. Implement the AI tool immediately to gain a competitive advantage, assuming that any potential issues can be addressed reactively as they arise. The correct answer is C. Conduct a thorough due diligence process, including independent validation of the AI's accuracy and bias mitigation strategies, verification of robust data security and confidentiality protocols, and defining clear parameters for human oversight of AI-generated outputs before recommending adoption. Explanation. This scenario presents a professional challenge due to the inherent tension between leveraging advanced AI tools for efficiency and the paramount duty of competence and client confidentiality. The Certified Legal Technology Professional, CLTP, must navigate the ethical landscape of AI adoption, ensuring that technological advancements do not compromise professional obligations. The core of the challenge lies in balancing the potential benefits of AI in legal research and document review against the risks of algorithmic bias, data security, and the unauthorized practice of law. Correct approach emphasizes a thorough, risk-based evaluation of the AI tool, focusing on its validation, security protocols, and the human oversight required. This aligns with the CLTP responsibility to ensure that any technology employed is fit for purpose and does not expose the firm or its clients to undue risk. Specifically, it reflects the ethical imperative to maintain competence by understanding the limitations and potential pitfalls of AI, and to uphold client confidentiality by ensuring robust data security measures are in place. The CLTP must act as a gatekeeper, ensuring that AI is a tool to augment, not replace, professional judgment and ethical responsibility. An incorrect approach that relies solely on the vendor's assurances without independent verification fails to meet the standard of due diligence. This bypasses the CLTP responsibility to critically assess the technology's suitability and potential risks, potentially leading to breaches of confidentiality if data security is inadequate, or to incompetent advice if the AI's outputs are flawed due to bias or error. This approach neglects the professional obligation to understand the tools being used and their implications. Another incorrect approach that prioritizes cost savings over a comprehensive risk assessment is ethically unsound. While efficiency is a desirable outcome, it cannot come at the expense of client welfare, data integrity, or professional competence. This approach demonstrates a failure to prioritize ethical obligations over financial considerations, potentially exposing the firm to significant liability and reputational damage. Further incorrect approach that focuses exclusively on the speed of AI deployment, without considering the implications for accuracy and ethical compliance, is also professionally unacceptable. The rapid adoption of technology should not overshadow the fundamental requirements of providing competent and ethical legal services. This approach risks introducing errors, biases, and security vulnerabilities into legal processes, undermining the integrity of legal work. The professional decision-making process for similar situations should involve a structured, multifaceted evaluation. This includes 1. Identifying the specific legal technology and its intended application. 2. Assessing the potential benefits and risks, including ethical, security, and accuracy considerations. 3. Researching and validating the technology, including understanding its underlying algorithms, data sources, and security measures. 4. Evaluating the need for human oversight and the extent of that oversight. 5. Ensuring compliance with all relevant professional conduct rules and data protection regulations. 6. Documenting the evaluation process and the rationale for adoption or rejection of the technology. Question 9. Risk assessment procedures indicate that the firm is considering implementing several new legal technology software categories to enhance efficiency and client service. These include a comprehensive practice management system, a sophisticated document automation tool, an advanced e-discovery platform, a robust legal research suite, and a dedicated contract management solution. The primary implementation challenge identified is ensuring that the chosen software for each category meets stringent data security, client confidentiality, and regulatory compliance requirements specific to the UK legal sector, without creating integration conflicts or operational bottlenecks. Which of the following implementation strategies best addresses these multifaceted challenges? Option A. Prioritize a single, integrated platform that claims to offer functionalities across all identified legal tech software categories, assuming a unified approach will simplify compliance and security management. Option B. Implement all new legal technology software simultaneously to achieve immediate firm-wide efficiency gains, deferring detailed security and compliance reviews until after the initial rollout to avoid delaying the project timeline. Option C. Conduct a thorough, category-specific risk assessment and due diligence process for each legal tech software category, selecting best-of-breed solutions and developing a phased integration plan that addresses data security, privacy, and regulatory compliance for each independently before full deployment. Option D. Focus solely on the cost-effectiveness and user-friendliness of each software solution, with a secondary consideration for security and compliance, assuming that reputable vendors will inherently meet regulatory standards. The correct answer is A. Prioritize a single, integrated platform that claims to offer functionalities across all identified legal tech software categories, assuming a unified approach will simplify compliance and security management. Explanation. This scenario presents a common implementation challenge in legal technology, selecting and integrating software that addresses multiple practice needs without compromising data security, regulatory compliance, and operational efficiency. The challenge lies in balancing the desire for comprehensive functionality with the inherent risks associated with adopting new technologies, particularly in a regulated environment like legal practice. Professionals must navigate the complexities of vendor vetting, data privacy, integration compatibility, and user adoption, all while adhering to strict professional obligations. The correct approach involves a phased, risk-based implementation strategy that prioritizes data security and regulatory compliance from the outset. This approach acknowledges that different legal tech software categories have distinct security and compliance requirements. For instance, e-discovery platforms handle highly sensitive client data and are subject to stringent data preservation and chain of custody rules, while document automation software might focus more on intellectual property protection and version control. A thorough due diligence process for each software category, including detailed security audits, data privacy impact assessments, and verification of compliance with relevant professional conduct rules and data protection legislation, is paramount. This ensures that the chosen solutions not only meet functional needs, but also uphold the firm's ethical and legal duties to clients and regulatory bodies. An incorrect approach would be to adopt a one-size-fits-all solution, without adequate consideration for the specific risks and regulatory nuances of each legal tech software category. For example, implementing a practice management system that also claims to handle contract management without a specific review of its contract lifecycle management features and associated data security protocols would be a failure. This could lead to breaches of client confidentiality, inadequate data integrity for contracts, and non-compliance with regulations governing the handling of sensitive legal documents. Another failure would be to prioritize cost savings or perceived ease of integration over robust security and compliance checks for e-discovery tools. This could result in the mishandling of evidence, potential spoliation of data, and severe legal repercussions, including sanctions and disciplinary action. Furthermore, neglecting to assess the data residency and cross-border data transfer implications of cloud-based legal research tools could violate data protection laws. A professional reasoning process for navigating such challenges should involve a structured risk assessment framework. This begins with identifying all potential legal tech software categories that could benefit the firm. For each category, a detailed analysis of functional requirements, data security needs, and relevant regulatory obligations should be conducted. This should be followed by a rigorous vendor selection process that includes comprehensive due diligence, contract review focusing on data protection clauses, and pilot testing. Finally, a phased rollout with ongoing monitoring and periodic reassessment of risks and compliance is essential to ensure sustained effectiveness and adherence to professional standards. Question 10. Operational review demonstrates that a law firm is considering migrating client case management systems to a cloud-based solution to enhance accessibility and collaboration. The firm has identified several potential providers, but has not yet conducted in-depth security audits or reviewed their data processing agreements beyond standard vendor questionnaires. The firm's IT department has highlighted potential cost savings and improved scalability as key benefits. Which of the following represents the most compliant and ethically sound approach to adopting this cloud computing solution, considering the firm's obligations under UK data protection law and professional conduct rules? Option A. Delegate the entire responsibility for cloud security and compliance to the chosen cloud provider, focusing solely on the firm's internal operational efficiency and user experience during the migration process. Option B. Engage a specialized legal technology consultant to conduct a comprehensive risk assessment of the proposed cloud solution, scrutinize the provider's security certifications and data handling practices, and negotiate robust data processing agreements that explicitly address UK GDPR requirements and the SRA principles before proceeding with the migration. Option C. Prioritize the provider offering the most advanced collaboration features, assuming that technological innovation inherently implies a high level of security and compliance with data protection laws. Option D. Proceed with the migration to the most cost-effective cloud provider, assuming their standard security measures are adequate and relying on the provider's general compliance statements to meet regulatory requirements. The correct answer is D. Proceed with the migration to the most cost-effective cloud provider, assuming their standard security measures are adequate and relying on the provider's general compliance statements to meet regulatory requirements. Explanation. Scenario analysis. This scenario presents a common challenge in legal practice, balancing the adoption of innovative technology like cloud computing with the paramount duty to protect client confidentiality and comply with stringent data protection regulations. The challenge lies in understanding the nuanced risks associated with cloud environments, particularly concerning data sovereignty, access controls, and vendor security, all while ensuring that the firm's technological advancements do not inadvertently lead to regulatory breaches or ethical lapses. The firm must navigate the complexities of shared responsibility models in cloud security and the potential for unauthorized access or data loss, which could have severe consequences for client trust and legal standing. Correct approach analysis. The correct approach emphasizes a proactive, risk-based strategy for cloud adoption. This involves conducting thorough due diligence on potential cloud service providers, scrutinizing their security certification, data handling policies, and incident response plans. It necessitates understanding the specific regulatory requirements applicable to the firm's practice areas and client data, such as the UK GDPR and the SRA principles, to ensure the chosen cloud solution meets these standards. Implementing robust contractual safeguards, including data processing agreements that clearly define responsibilities and liabilities, is crucial. Furthermore, establishing clear internal policies for data classification, access management, and employee training on cloud security best practices is essential for mitigating risks and maintaining compliance. This approach aligns with the SRA's guidance on technology and outsourcing, which mandates a prudent and risk-aware adoption of technology to safeguard client interests and maintain professional integrity. Incorrect approaches analysis. One incorrect approach involves assuming that a cloud provider's standard terms of service are sufficient without independent verification of their security posture and compliance with relevant UK data protection laws. This failure to conduct due diligence exposes the firm to significant risks, as the provider's assurances may not adequately address the specific data protection obligations under the UK GDPR. Another incorrect approach is to prioritize cost savings or perceived efficiency over security and compliance. This can lead to the selection of less secure cloud solutions or inadequate contractual protection, potentially resulting in data breaches and regulatory penalties. A third incorrect approach is to delegate all security responsibilities to the cloud provider without establishing internal oversight and controls. This overlooks the shared responsibility model inherent in cloud computing and the firm's ultimate accountability for client data protection. Such an approach would violate the SRA principles regarding acting with integrity and in the best interests of clients. Professional reasoning. Professionals should adopt a structured, risk-aware framework for evaluating and implementing cloud computing solutions. This framework should include 1. Identifying all applicable regulatory requirements, e.g., UK GDPR SRA principles. 2. Conducting comprehensive risk assessments of potential cloud services, focusing on data security, privacy, and compliance. 3. Performing thorough vendor due diligence, including reviewing security certifications, audit reports, and contractual terms. 4. Developing and implementing robust internal policies and procedures for cloud usage, data management, and incident response. 5. Ensuring ongoing monitoring and review of cloud service performance and compliance. This systematic approach ensures that technological adoption is aligned with legal obligations and ethical duties, thereby protecting both the firm and its clients. Question 11. Strategic planning requires a law firm to implement a robust e-discovery process, considering the potential for ongoing business operations to overwrite or delete critical data. Which of the following approaches best ensures defensibility and compliance with legal and ethical obligations throughout the e-discovery lifecycle? Option A. Delegate the entire e-discovery process to IT personnel without direct legal oversight, trusting their technical expertise to manage data preservation and collection effectively. Option B. Develop and implement a comprehensive e-discovery plan that clearly defines identification and preservation protocols before any collection begins, followed by systematic collection, processing, review, and analysis, with thorough documentation at each stage. Option C. Focus primarily on collecting data from the most accessible sources, assuming that less accessible data is less likely to be relevant, and expedite the review process to meet tight deadlines. Option D. Immediately initiate broad data collection from all active systems upon notification of potential litigation, relying on advanced analytics to filter for relevance during the review phase. The correct answer is D. Immediately initiate broad data collection from all active systems upon notification of potential litigation, relying on advanced analytics to filter for relevance during the review phase. Explanation: this scenario presents a common challenge in legal technology, balancing the need for efficient e-discovery with the stringent requirements of data preservation and defensibility. The core difficulty lies in the inherent tension between rapid information retrieval for business operations and the legal obligation to maintain data integrity for potential litigation. Professionals must navigate this by implementing a robust e-discovery process that is both technologically sound and legally compliant. The correct approach prioritizes a comprehensive, phased e-discovery strategy that begins with clear identification and preservation protocols. This aligns with the fundamental principles of e-discovery, emphasizing that all potentially relevant electronically stored information, ESI, must be identified and preserved before any collection or processing occurs. This proactive stance minimizes the risk of spoliation and ensures that the collected data is a true and accurate reflection of the information at the relevant time. Adherence to these principles is critical for meeting regulatory obligations and ethical duties to the court and clients. Incorrect approaches often stem from a failure to adequately address the initial stages of the e-discovery process. Prioritizing collection without proper identification and preservation can lead to the inadvertent destruction or alteration of critical evidence, constituting a serious regulatory and ethical breach. This can result in sanctions, adverse inferences, and damage to the client's case. Similarly, attempting to bypass the systematic review and analysis phases in favor of immediate production, without thorough validation of relevance and privilege, risks producing incomplete, irrelevant, or privileged information, which can also lead to legal repercussions and ethical violations. The failure to document each step of the e-discovery process, a common oversight, undermines the defensibility of the entire effort and can be viewed as a failure to meet professional standards. The professional decision-making process for such situations should involve a structured, risk-based approach. This begins with a thorough understanding of the legal and regulatory landscape governing e-discovery. It then requires close collaboration with legal counsel to define the scope of discoverable ESI and establish clear preservation obligations. Implementing a documented, repeatable e-discovery workflow that incorporates best practices for each stage: identification, preservation, collection, processing, review, analysis, production, and presentation is paramount. Regular training and updates on evolving technologies and legal precedents are also essential to maintain competence and ensure compliance. Question 12. Compliance review shows that while the firm has a documented data retention policy, there is a lack of clarity on how specific client matter data, including sensitive personal information and proprietary documents, is categorized and managed across different practice groups. The Legal Technology Department is considering implementing a new, firm-wide data discovery tool. Which of the following actions best addresses the identified compliance gap? Option A. Focus solely on enhancing the technical capabilities of the data discovery tool to ensure it can scan all network drives and cloud storage, assuming that comprehensive technical coverage will inherently address data governance requirements. Option B. Immediately deploy the new data discovery tool across the entire firm, relying on its automated classification features to identify and categorize all data, and then provide general training on data management to all staff. Option C. Request that each practice group independently document their data holdings and management processes, and then consolidate these disparate reports into a single firm-wide data inventory. Option D. Conduct a series of workshops with each practice group to map their data types, understand their data workflows, and identify where sensitive data resides, before configuring and deploying the data discovery tool based on these findings. The correct answer is D. Conduct a series of workshops with each practice group to map their data types, understand their data workflows, and identify where sensitive data resides, before configuring and deploying the data discovery tool based on these findings. Explanation: this scenario presents a common challenge in legal technology. Ensuring robust data governance practices are not merely documented but actively implemented and understood across different departments. The professional challenge lies in translating high-level policy into actionable, department-specific procedures, especially when dealing with diverse data types and varying levels of technical expertise. The need for careful judgment arises from balancing the imperative of regulatory compliance with the practicalities of daily operations, and the potential impact on departmental workflows. The correct approach represents best professional practice because it directly addresses the core of information governance, understanding data at its source and implementing controls relevant to its context. By engaging departmental stakeholders, the legal technology professional ensures that data mapping is not an abstract exercise, but a practical tool that informs policy and procedure. This aligns with the principles of data minimization, purpose limitation, and accountability, which are foundational to data protection regulations. Specifically, it fosters a proactive approach to identifying sensitive data, understanding its life cycle, and implementing appropriate security and retention measures, thereby mitigating risks of breaches and noncompliance. An incorrect approach that focuses solely on a centralized, IT-driven data inventory without departmental input fails to capture the nuances of how data is actually created, used, and stored within specific business units. This can lead to an incomplete or inaccurate data map, overlooking critical data sets or misclassifying data sensitivity. Ethically and regulatorily, this can result in a failure to adequately protect personal data or meet specific record-keeping obligations, as the controls implemented may not be fit for purpose for the actual data being handled. Another incorrect approach that relies on generic data classification, without understanding departmental workflows, risks over or underclassifying data. This can lead to unnecessary burdens on departments for low-risk data or, conversely, insufficient protection for high-risk data. This failure to tailor controls to the specific data and its context is a direct contravention of principles of proportionality and risk-based data management, which are central to most data protection frameworks. A further incorrect approach that prioritizes technical solutions over understanding data context can result in implementing sophisticated data management tools that are not aligned with how departments actually operate. This can lead to user resistance, workarounds that bypass controls, and ultimately, a breakdown in the intended governance framework. The regulatory failure here is in not establishing effective and practical controls that are embedded within the operational environment, leading to a gap between policy and practice. The professional reasoning process should involve a phased approach. First, understanding the overarching regulatory requirements and organizational policies. Second, engaging with departmental stakeholders to understand their data landscapes and operational realities. Third, developing a data mapping methodology that is both comprehensive and practical. And finally, collaborating with departments to implement and maintain data governance controls that are tailored to their specific needs and data types, ensuring ongoing compliance and risk mitigation. Question 13. Market research demonstrates that law firms are increasingly relying on cloud-based collaboration tools for client document management and internal communication. A new associate at a mid-sized firm, tasked with managing a complex litigation matter, receives numerous documents via email and through shared cloud folders. The associate, focused on efficiently organizing the documents for review, saves them directly into the firm's document management system without considering the embedded metadata. The firm has a general policy on document retention, but lacks specific guidelines on metadata preservation for active litigation matters. Which of the following approaches best addresses the firm's obligations regarding metadata preservation in this scenario? Option A. Advise the associate to manually review each document for any visible metadata and to save a separate copy of the document with any identified metadata before filing it in the document management system. Option B. Wait until a discovery request specifically asks for metadata before implementing any measures to preserve or collect it, assuming the firm's standard document management system adequately handles such information. Option C. Implement automated metadata capture and preservation tools at the point of document ingestion into the firm's systems, alongside a clear, firm-wide policy and mandatory training for all legal staff on the importance and handling of metadata in litigation. Option D. Instruct the associate to only focus on preserving the content of the documents and to disregard any metadata, as it is generally considered secondary information and not crucial for litigation. The correct answer is C. Implement automated metadata capture and preservation tools at the point of document ingestion into the firm's systems, alongside a clear, firm-wide policy and mandatory training for all legal staff on the importance and handling of metadata in litigation. Explanation. Scenario analysis. This scenario presents a common challenge in legal technology, where the rapid pace of digital communication and document creation can lead to the inadvertent loss or alteration of critical metadata. The professional challenge lies in balancing the need for efficient workflow and client service with the stringent legal and ethical obligations to preserve evidence accurately and completely. Failure to do so can have severe consequences, including the inadmissibility of evidence, sanctions, and reputational damage. Careful judgment is required to implement robust metadata preservation strategies that are both effective and practical within the firm's operational context. Correct approach analysis. The correct approach emphasizes proactive measures and a comprehensive understanding of metadata's role in legal proceedings. Implementing automated tools for metadata capture at the point of creation or ingestion, coupled with clear firm-wide policies and regular training, ensures that metadata is preserved consistently and accurately. This aligns with the principles of e-discovery and evidence handling, which mandate the preservation of all relevant information, including metadata, to maintain the integrity and authenticity of digital evidence. Adherence to these practices is crucial for compliance with rules of professional conduct and relevant legal frameworks governing evidence. Incorrect approaches analysis. One incorrect approach involves relying solely on manual methods for metadata preservation. This is professionally unacceptable because manual processes are prone to human error, inconsistency, and oversight, especially in high-volume environments. It fails to meet the standard of due diligence required for evidence preservation and can lead to the accidental or intentional deletion of crucial metadata, violating ethical obligations to maintain the integrity of client information and potential evidence. Another incorrect approach is to only consider metadata preservation when litigation is imminent. This is a reactive and insufficient strategy. Legal and ethical obligations to preserve relevant information, including metadata, often arise much earlier in the life cycle of a matter. Waiting until litigation is threatened can result in the irreversible loss of metadata, making it impossible to reconstruct the context or authenticity of digital documents, thereby failing to meet the duty of care owed to clients and potentially violating discovery obligations. A third incorrect approach is to assume that standard document management systems automatically preserve all relevant metadata in a forensically sound manner. While some systems offer metadata capture, they may not capture all types of metadata or preserve it in a way that is admissible in court. Relying on such assumptions without verification can lead to gaps in preservation, making evidence unreliable and potentially subject to challenge. This demonstrates a lack of due diligence in understanding the capabilities and limitations of the firm's technology in relation to legal requirements. Professional reasoning. Professionals should adopt a risk-based approach, identifying critical data types and workflows where metadata is most likely to be relevant and valuable. This involves understanding the specific types of metadata, e.g., creation date, author, modification history, access logs, and their potential evidentiary significance. Implementing a layered strategy that combines technological solutions with clear policies, ongoing training, and regular audits is essential. Professionals must also stay abreast of evolving legal standards and technological advancements in e-discovery and digital forensics to ensure their practices remain compliant and effective. A proactive, documented, and defensible approach to metadata preservation is paramount. Question 14. The performance metrics show a significant increase in client onboarding time and a corresponding rise in administrative overhead. To address this, the firm is considering implementing a new AI-powered client intake platform. Which of the following approaches best aligns with the professional obligations of a certified legal technology professional in ensuring the responsible adoption of this technology? Option A. Select the platform with the lowest upfront cost and fastest implementation timeline, as efficiency gains will ultimately benefit clients through reduced overall legal fees. Option B. Prioritize the platform that offers the most advanced AI features and promises the greatest reduction in onboarding time, assuming the vendor's standard terms of service adequately cover data protection. Option C. Implement the platform immediately to gain a competitive advantage and address any potential data security or compliance issues that may arise after the initial rollout. Option D. Conduct a comprehensive risk assessment of the AI platform, including its data security protocols, vendors' compliance certifications, data handling practices, and potential impact on client confidentiality before any deployment. Correct answer is B. Prioritize the platform that offers the most advanced AI features and promises the greatest reduction in onboarding time, assuming the vendor's standard terms of service adequately cover data protection. Explanation. Scenario analysis. This scenario presents a common challenge in legal technology implementation, balancing the drive for efficiency and cost reduction with the paramount duty of client confidentiality and data security. The firm is experiencing increased workload and client demand, necessitating technological solutions. However, the selection and deployment of these technologies must adhere strictly to the regulatory framework governing legal practice and data protection. The challenge lies in identifying solutions that enhance operational capacity without compromising the integrity of client information or violating professional conduct rules. This requires a nuanced understanding of both technological capabilities and legal obligations. Correct approach analysis. The correct approach prioritizes a comprehensive risk assessment and due diligence process before adopting any new legal technology. This involves evaluating the technology's security features, data handling protocols, vendor reliability, and compliance with relevant regulations such as the SRA principles and code of conduct, if UK jurisdiction is assumed for CLTP. Specifically, Principle 4 of the SRA principles mandates that solicitors must act in the best interests of their clients, which includes protecting their confidential information. The Code of Conduct further elaborates on this, requiring firms to have robust systems and controls in place to safeguard client data. A thorough assessment ensures that any chosen technology aligns with these ethical and regulatory imperatives, thereby upholding client trust and minimizing the risk of data breaches or misuse. This methodical approach demonstrates professional responsibility and adherence to the highest standards of client care. Incorrect approach is analysis. Adopting a new technology solely based on its perceived cost savings or efficiency gains without a thorough security and compliance review is a significant regulatory and ethical failure. This approach risks violating client confidentiality, SRA Principle 4, failing to act in the best interests of clients, SRA Principle 4, and potentially contravening data protection laws. For instance, selecting a cloud-based solution without verifying the vendor's data encryption standards, data residency policies, or incident response plans could expose sensitive client information to unauthorized access or loss. Implementing a technology that has not undergone a formal risk assessment or pilot testing phase, especially if it involves handling sensitive client data, is also problematic. This can lead to unforeseen technical issues, data corruption, or security vulnerabilities that could compromise client information. Such a failure to exercise due diligence demonstrates a lack of professional care and could result in disciplinary action for breaches of professional conduct. Relying on vendor assurances alone without independent verification of security claims or compliance certifications is another flawed approach. Vendors may present their products in the most favorable light, and it is the legal professional's responsibility to ensure that these claims are substantiated and that the technology meets the firm's specific regulatory and ethical obligations. Failure to do so can lead to a false sense of security and expose the firm and its clients to unacceptable risks. Professional reasoning. Professionals should employ a structured decision-making framework that begins with identifying the business need or problem. This is followed by researching potential technological solutions, but critically, each solution must be evaluated against a predefined set of criteria that includes security, compliance, ethical implications, and client confidentiality, in addition to functionality and cost. A thorough due diligence process, including vendor vetting, security audits, and pilot testing, is essential. The decision should be based on a comprehensive understanding of the risks and benefits, ensuring that client interests and regulatory requirements are always prioritized. This systematic approach fosters responsible innovation and upholds the integrity of the legal profession. Question 15. Operational review demonstrates that a legal team is preparing for litigation involving complex financial transactions. The initial data collection phase involved creating forensic image files of all relevant servers and workstations. However, the team is now debating whether to prioritize the preservation and production of native files for all documents, or if the forensic image files alone are sufficient for e-discovery purposes. Given the time and resource constraints, what is the most appropriate approach to ensure comprehensive and legally defensible e-discovery in this scenario, considering the implications of data types and formats? Option A. Collect only the most critical native files identified by the legal team, and supplement with image files only for backup purposes, assuming most relevant data will be in easily accessible native formats. Option B. Prioritize the collection and preservation of native files for all documents, alongside forensically sound image files of the storage media, to ensure all metadata and original formatting are retained. Option C. Focus on extracting all text-based content from both native and image files, and disregard any complex metadata or file-specific formatting that is not directly readable as plain text. Option D. Rely solely on the forensic image files, as they represent a complete snapshot of the data at the time of imaging, and discard native files to save on storage and processing costs. The correct answer is B. Prioritize the collection and preservation of native files for all documents, alongside forensically sound image files of the storage media, to ensure all metadata and original formatting are retained. Explanation. Scenario analysis. This scenario presents a common challenge in legal technology where the initial collection of electronic evidence may not fully account for the nuances of data types and their preservation. The firm's reliance on image files without considering native formats and associated metadata creates a significant risk of incomplete or inadmissible evidence. The professional challenge lies in balancing the urgency of data preservation with the technical complexities of handling diverse electronic data, ensuring that all relevant information is captured in a forensically sound manner that meets legal standards. Correct approach analysis. The correct approach prioritizes the preservation of data in its native format whenever possible, alongside the creation of forensically sound image files. This is best professional practice because native files retain their original structure, formatting, and crucially, their associated metadata. Metadata, such as creation dates, modification dates, author information, and access logs, is often critical for establishing the authenticity, context, and chain of custody of electronic evidence. Regulatory frameworks, such as those governing e-discovery in the U.S., e.g., Federal Rules of Civil Procedure, particularly Rule 26b, 2b, concerning proportionality and discoverability of electronically stored information, emphasize the need for relevant and non-privileged information. Preserving native files ensures that this rich metadata is available for analysis, which can be essential for proving or disproving claims, understanding document lineage, and demonstrating compliance with discovery obligations. Image files, while valuable for preserving the exact state of a drive, may not fully capture all metadata or the interactive elements of certain file types, e.g., complex spreadsheets with formulas, databases. Therefore, a comprehensive approach that includes both native files and forensic images, where appropriate, is essential for robust e-discovery. Incorrect approaches analysis. One incorrect approach involves solely relying on image files and discarding native files after imaging. This is professionally unacceptable because it risks the loss of critical metadata that is not fully captured or accessible within the image file itself. This can lead to incomplete discovery, potential sanctions for spoliation of evidence, and an inability to effectively analyze the data in court. It fails to meet the spirit of discovery rules that require the production of relevant information in a usable format. Another incorrect approach is to collect only readily accessible native files without considering the potential for hidden or embedded data, or the need for forensic imaging of the entire storage medium. This can result in a fragmented and incomplete collection, missing crucial evidence that might reside in unallocated space or within complex file structures. It also overlooks the importance of a forensically sound process for establishing the integrity of the collected data. A third incorrect approach is to prioritize speed of collection over thoroughness, leading to the improper handling of metadata or the failure to identify and preserve all relevant data types. This can result in the inadvertent destruction or alteration of evidence, a direct violation of ethical obligations and potentially legal sanctions. It demonstrates a lack of understanding of the technical requirements for effective e-discovery. Professional reasoning. Professionals should adopt a phased approach to data collection. First, conduct a thorough forensic analysis to identify all potential sources of relevant data and the types of data present. Second, develop a defensible collection strategy that prioritizes the preservation of data in its native format, supplemented by forensically sound imaging where necessary. Third, ensure that all collected data, including metadata, is properly documented, cataloged, and maintained in a secure environment to preserve the chain of custody. This systematic and technically informed process ensures compliance with legal and ethical obligations, maximizes the utility of the collected evidence, and mitigates the risks associated with e-discovery. Question 16. The control framework reveals that a law firm is managing a significant volume of client data across various formats, including legacy, electronic documents, cloud-based collaboration platforms, and audio-visual recordings. The firm needs to establish a robust strategy for preserving this data to meet ongoing legal and regulatory obligations. Which of the following approaches best aligns with best practices for data preservation in this context? Option A. Prioritize the preservation of only the most recent versions of electronic documents, assuming older iterations are redundant and less relevant for future legal needs. Option B. Store all client data on readily accessible cloud storage services without specific archival features, relying on the service provider's general data redundancy measures. Option C. Adopt a reactive approach, only initiating data preservation efforts when a specific legal hold notice is received from a party involved in litigation. Option D. Implement a tiered preservation strategy that categorizes data based on its legal significance and retention period, employing forensically sound collection and secure, documented storage with regular integrity checks for all tiers. The correct answer is D. Implement a tiered preservation strategy that categorizes data based on its legal significance and retention period, employing forensically sound collection and secure, documented storage with regular integrity checks for all tiers. Explanation. This scenario is professionally challenging because legal technology professionals must balance the imperative of data preservation with the practicalities of evolving data formats and the potential for data degradation or obsolescence. The sheer volume and diversity of data encountered in legal contexts, from traditional documents to ephemeral digital communications, demand a proactive and adaptable preservation strategy. Failure to implement robust strategies can lead to the loss of critical evidence, rendering it inadmissible or unusable in legal proceedings, and exposing the firm to sanctions or reputational damage. The correct approach represents best professional practice because it prioritizes a defensible and systematic method for identifying, collecting, and preserving data in a manner that maintains its integrity and authenticity. This involves understanding the specific legal and regulatory requirements for data retention and preservation within the relevant jurisdiction, which for this exam is assumed to be the United Kingdom, adhering to principles outlined by bodies like the National Archives and relevant professional conduct rules for solicitors and barristers. A tiered approach, categorizing data based on its legal significance and retention period, allows for efficient allocation of resources and ensures that the most critical data receives the highest level of preservation. This includes employing forensically sound collection methods, utilizing appropriate storage media with documented chain of custody, and implementing regular integrity checks. Goal is to ensure that data remains accessible and unaltered for the duration of its required retention period, or until its legal relevance has expired. An incorrect approach that relies solely on the most recent version of a document without preserving prior iterations fails to meet preservation requirements. This is because legal matters often hinge on the evolution of information, and earlier versions may contain crucial context, amendments, or evidence of intent. Such an approach risks violating the duty to preserve relevant evidence, potentially leading to adverse inferences or sanctions. Another incorrect approach that involves storing data on easily accessible but volatile media, such as standard cloud storage without specific archival features or without proper access controls and audit trails, is also professionally unacceptable. This method increases the risk of accidental deletion, unauthorized modification, or data corruption, thereby compromising data integrity and the chain of custody. This directly contravenes the need for secure and reliable long-term storage mandated by preservation best practices and potentially by data protection regulations like GDPR if personal data is involved. A further incorrect approach of only preserving data that is explicitly requested by a party, without a proactive internal policy for identifying and preserving potentially relevant data, is a significant ethical and regulatory failure. This reactive stance can lead to the inadvertent destruction of discoverable information, undermining the principles of full disclosure and potentially leading to spoliation of evidence. Professional decision-making in data preservation requires a proactive, risk-based approach. Legal technology professionals must first understand the legal and regulatory landscape governing data preservation in their jurisdiction. They should then develop and implement a comprehensive data management policy that includes clear guidelines for data identification, collection, storage, and disposition. Regular training for all staff on their roles in data preservation is also crucial. When faced with a specific preservation task, professionals should assess the nature of the data, its potential relevance, the applicable legal hold requirements, and the most appropriate preservation methods to ensure data integrity and defensibility. Question 17. Quality control measures reveal that a legal team is preparing to collect data from a key witness's laptop for an ongoing investigation. The primary objective is to secure all email communications related to a specific project, while also preserving the integrity of the entire laptop's contents for potential future analysis. The team is considering several methods for data acquisition. Which approach best balances the need for targeted evidence with the requirement for a forensically sound and defensible collection? Option A. Instruct the witness to export all their email communications to a portable drive and submit that drive for analysis. Option B. Perform a forensic image of the entire laptop hard drive and then extract the relevant email data from the forensic image. Option C. Conduct a targeted collection of only the email files from the live operating system, bypassing any imaging process. Option D. Remotely access the laptop and directly copy all email files to a secure server, without creating a bit-for-bit copy of the drive. Correct answer is B. Perform a forensic image of the entire laptop hard drive and then extract the relevant email data from the forensic image. Explanation. This scenario presents a common challenge in legal technology, balancing the need for comprehensive data collection with the practical constraints of time, cost, and the potential for data spoliation. The professional challenge lies in selecting the most appropriate collection method that adheres to the principles of data integrity, defensibility, and proportionality, all while remaining compliant with the relevant regulatory framework for the Certified Legal Technology Professional (CLTP) exam. Careful judgment is required to avoid overcollection, which can lead to unnecessary expense and complexity, or undercollection, which could result in the loss of critical evidence. The correct approach represents best professional practice because it prioritizes the preservation of data integrity and the defensibility of the collection process. Forensic imaging, when applied to targeted data sources, ensures that a bit-for-bit copy of the original media is created, thereby preventing any alteration of the source data. This method is crucial for maintaining the chain of custody and providing irrefutable evidence of the data's state at the time of collection. Adherence to established forensic protocols, as expected under CLTP standards, ensures that the collection is both legally sound and technically robust. An incorrect approach that relies solely on remote collection without proper forensic imaging of critical data sources would fail to meet the defensibility requirements. Remote collection, while efficient, can introduce risks of data alteration or incomplete capture if not executed with rigorous forensic controls. Without a forensic image, it becomes difficult to prove that the collected data is an exact replica of the original, potentially jeopardizing its admissibility in legal proceedings. Another incorrect approach, such as a broad, untargeted collection of all data from a user's device, would likely violate principles of proportionality and data minimization, leading to excessive costs and the collection of irrelevant information, which can be ethically questionable and procedurally inefficient. A third incorrect approach, focusing only on user-exported data without any forensic validation, would be highly susceptible to manipulation and would not provide the necessary assurance of data integrity required in a legal context. The professional decision-making process for similar situations should involve a thorough assessment of the case's specific needs, including the type of data sought, the potential sources, and the legal and regulatory requirements. This assessment should then guide the selection of a collection method that balances defensibility, efficiency, and cost-effectiveness. Professionals should always prioritize methods that ensure data integrity and maintain a clear, unbroken chain of custody, consulting with legal counsel and forensic experts as necessary to ensure compliance and defensibility. Question 18. The control framework reveals that a legal technology team is responsible for managing electronic data for a client engaged in ongoing litigation. The team has identified that certain data, while no longer actively used for daily business operations, falls within the client's standard 7-year data retention policy, which dictates automatic deletion of data after this period. The litigation has been active for 3 years. The team is considering proceeding with the automatic deletion of this data as per the retention policy, assuming it is permissible because the data is older than 3 years but not yet 7 years old. Option A. Delete the data immediately, as it is no longer actively used for business operations, and rely on the cloud provider's backup and recovery systems to restore it if needed. Option B. Proceed with the automatic deletion of the data as it is still within the 7-year retention period and not actively used for business operations. Option C. Inform the client that the data will be deleted according to the retention policy and await further instructions without actively intervening to preserve it. Option D. Implement a legal hold on the identified data, overriding the standard retention policy for the duration of the litigation, and consult with legal counsel to confirm the scope and duration of preservation. Correct answer is D. Implement a legal hold on the identified data, overriding the standard retention policy for the duration of the litigation, and consult with legal counsel to confirm the scope and duration of preservation. Explanation. This scenario presents a significant professional challenge due to the inherent tension between the need to preserve evidence for potential litigation and the operational realities of managing and deleting electronic data. The Certified Legal Technology Professional, CLTP, must navigate complex legal obligations regarding data preservation, understand the severe consequences of spoliation, and implement robust controls to prevent accidental or intentional data destruction. The challenge lies in balancing legal compliance with business efficiency, requiring a nuanced understanding of discovery rules and ethical duties. The correct approach represents best professional practice because it prioritizes proactive identification and preservation of potentially relevant data. This aligns with the fundamental principles of e-discovery and the duty to preserve evidence once litigation is reasonably anticipated. Specifically, it demonstrates adherence to the principles of good faith preservation, a cornerstone of legal technology practice. By implementing a legal hold process that is clearly communicated and technically enforced, the CLTP ensures that data is not inadvertently or deliberately destroyed, thereby mitigating the risk of sanctions. This proactive stance is crucial for demonstrating diligence and compliance with discovery obligations, which are often governed by rules of civil procedure, and case law emphasizing the importance of preserving discoverable information. An incorrect approach that involves relying solely on standard data retention policies without a specific legal hold is professionally unacceptable. This fails to acknowledge the legal obligation to preserve evidence once litigation is reasonably foreseeable, regardless of pre-existing retention schedules. Such an approach risks violating discovery rules, leading to adverse inferences, monetary sanctions, or even dismissal of claims or defenses. It demonstrates a lack of understanding of the dynamic nature of preservation obligations triggered by legal proceedings. Another incorrect approach, which is to delete data that is no longer deemed actively needed for business operations without consulting legal counsel or confirming the absence of a legal hold, is also a critical failure. This action directly constitutes spoliation if that data is later found to be relevant to litigation. It shows a disregard for the potential evidentiary value of data and a failure to engage with the legal team responsible for managing discovery. This can result in severe sanctions, including fines, preclusion of evidence, and reputational damage. A third incorrect approach, which is to assume that cloud provider automatic deletion policies will satisfy legal preservation obligations, is equally problematic. While cloud providers have their own retention mechanisms, these are typically for operational purposes and do not supersede a specific legal hold requirement. The CLTP has a direct responsibility to ensure that data relevant to litigation is preserved, and outsourcing this responsibility to a third party's default settings without verification is a dereliction of duty. This can lead to sanctions for failing to implement an effective legal hold. The professional decision-making process for similar situations should involve a clear framework. 1. Recognition of triggering event. Immediately identify events that reasonably anticipate litigation or investigation. 2. Consultation with legal counsel. Engage legal counsel to understand the scope of potential discovery and the specific data preservation requirements. 3. Implementation of legal hold. Issue a formal legal hold notice to all relevant custodians, clearly defining the scope of preserved data and the duration of the hold. 4. Technical enforcement. Utilize technology to enforce the legal hold, preventing deletion or alteration of the specified data. 5. Regular review and updates. Periodically review the legal hold to ensure its continued relevance and update it as necessary based on evolving litigation needs. 6. Documentation. Maintain thorough records of all actions taken, including the issuance of legal holds, communication with custodians, and any data management activities. Question 19. Cost-benefit analysis shows that implementing a comprehensive, multi-layered cybersecurity strategy, including regular vulnerability assessments, advanced endpoint protection, robust access controls, and ongoing employee training, would incur significant upfront and ongoing costs for the firm. However, the potential financial and reputational damage from a data breach, including regulatory fines under UK GDPR and loss of client confidence, is estimated to be substantially higher. Given the firm's reliance on legacy systems and the increasing sophistication of cyber threats, which of the following represents the most professionally responsible and legally compliant approach to cybersecurity? Option A. Focus solely on enhancing employee awareness training regarding phishing and malware, assuming that well-informed staff will be the primary defense against cyber threats, while deferring significant investment in technical security upgrades. Option B. Implement a comprehensive, risk-based cybersecurity strategy that includes regular assessments, advanced technical controls, strict access management, and continuous employee education, prioritizing the protection of client data and firm assets in line with regulatory obligations. Option C. Deploy a basic, widely available antivirus software across all systems, supplemented by occasional employee awareness emails, as a cost-effective measure to address immediate cybersecurity concerns. Option D. Postpone substantial cybersecurity investments until a data breach occurs or until the firm's financial situation significantly improves, arguing that the current budget does not permit a more robust security posture. The correct answer is B. Implement a comprehensive, risk-based cybersecurity strategy that includes regular assessments, advanced technical controls, strict access management, and continuous employee education, prioritizing the protection of client data and firm assets in line with regulatory obligations. Explanation. Scenario analysis. This scenario presents a common challenge for legal technology professionals, balancing the imperative to protect sensitive client data and firm assets with the practicalities of resource allocation and operational efficiency. The firm's reliance on legacy systems, coupled with the increasing sophistication of cyber threats, creates a significant vulnerability. The challenge lies in identifying and implementing appropriate cybersecurity measures that are both effective and proportionate to the risks, while also considering the firm's budget and the potential disruption to workflows. Failure to adequately address these risks can lead to severe consequences, including data breaches, financial losses, reputational damage, and regulatory penalties. Correct approach analysis. The correct approach prioritizes a comprehensive, risk-based strategy for cybersecurity. This involves conducting a thorough assessment of potential threats and vulnerabilities, understanding the sensitivity of the data being handled, and implementing a layered defense. This aligns with the principles of data protection and professional responsibility expected of legal professionals. Specifically, under the SRA principles and Code of Conduct for solicitors, firms have a duty to act with integrity and in the best interests of their clients. This includes taking reasonable steps to safeguard client information. The ICO's guidance on data protection under the UK GDPR also mandates appropriate technical and organizational measures to ensure a level of security appropriate to the risk. Proactive approach, including regular training, robust access controls, encryption, and incident response planning, is essential to meet these obligations. Incorrect approaches analysis. Implementing a one-size-fits-all basic antivirus solution without considering the specific vulnerabilities of legacy systems or the sensitivity of client data is insufficient. This approach fails to address the nuanced risks and may leave the firm exposed to more sophisticated attacks. It could be seen as a failure to take reasonable steps under the SRA Code of Conduct and a breach of the data protection principles under UK GDPR, which require a risk-based approach to security. Relying solely on employee awareness training without implementing technical safeguards is also inadequate. While training is crucial, it cannot be the sole defense. Human error is a significant factor in breaches, and technical controls are necessary to mitigate the impact of such errors. This approach could be considered a failure to implement appropriate technical and organizational measures as required by UK GDPR. Ignoring the issue due to budget constraints without a clear risk assessment and mitigation plan is a direct contravention of professional duties. The SRA principles require firms to act with integrity and competence, which includes managing risks effectively. Financial limitations do not excuse a failure to protect client data, and such inaction would likely lead to regulatory sanctions and a loss of client trust. Professional reasoning. Legal technology professionals must adopt a systematic and risk-aware approach to cybersecurity. This involves 1. Risk assessment. Continuously identify and evaluate potential threats and vulnerabilities specific to the firm's operations and the data it handles. 2. Proportionality. Implement security measures that are proportionate to the identified risks, considering the sensitivity of data and potential impact of a breach. 3. Layered defense. Employ a combination of technical, organizational, and procedural controls to create multiple barriers against threats. 4. Regular review and updates. Cybersecurity is an ongoing process. Regularly review and update security policies, technologies, and training to adapt to evolving threats. 5. Incident response planning. Develop and test a clear plan for responding to security incidents to minimize damage and ensure business continuity. 6. Compliance. Ensure all measures align with relevant regulatory frameworks, such as the SRA Principles, Code of Conduct, and UK GDPR. Question 20. System analysis indicates that a legal team is preparing for litigation involving allegations of intellectual property theft. The core of the dispute centers on communications and project-related documents exchanged between key employees and external parties over the past 3 years. The legal technology professional has identified that relevant data could reside in a variety of electronic sources, including company-provided email servers, cloud-based document repositories, e.g., OneDrive, Google Drive, employee mobile devices, and potentially public social media profiles of involved individuals. To ensure compliance with the U.S. Federal Rules of Civil Procedure and to preserve all potentially discoverable information, which of the following approaches is most appropriate for the initial data preservation and collection phase? Option A. Advise the legal team that only data explicitly requested by opposing counsel needs to be preserved, and focus collection efforts solely on those specific items to avoid unnecessary burden. Option B. Collaborate with legal counsel to define the scope of relevant data, identify all potential custodians and data sources, and develop a targeted, forensically sound collection plan that prioritizes sources based on their likelihood of containing relevant information, while ensuring proportionality. Option C. Immediately initiate a broad collection of all data from company email servers and all cloud-based document repositories, as these are typically the most accessible and contain the bulk of formal business communications. Option D. Begin collecting data from employee mobile devices and social media accounts first, as these sources are often overlooked and may contain the most incriminating evidence, without first consulting legal counsel on the scope. The correct answer is B. Collaborate with legal counsel to define the scope of relevant data, identify all potential custodians and data sources, and develop a targeted, forensically sound collection plan that prioritizes sources based on their likelihood of containing relevant information, while ensuring proportionality. Explanation. This scenario presents a common challenge in legal technology, ensuring comprehensive and compliant collection of electronic data for litigation or regulatory review. The professional challenge lies in the sheer volume and diversity of data sources, each with its own technical characteristics, access protocols, and potential for spoliation. A certified legal technology professional, CLTP, must navigate these complexities while adhering strictly to the relevant regulatory framework, which in this context is assumed to be the U.S. Federal Rules of Civil Procedure, FRCP, and applicable case law concerning electronic discovery, e-discovery. The correct approach represents best professional practice because it prioritizes a systematic, defensible, and compliant data preservation and collection strategy. It acknowledges the FRCP emphasis on proportionality and the need for a well-documented process. By engaging legal counsel early and developing a targeted collection plan based on the scope of the matter, the CLTP minimizes the risk of overcollection, which can be costly and burdensome, and undercollection, which can lead to spoliation sanctions. This proactive, collaborative approach ensures that all potentially relevant data is identified and preserved in a forensically sound manner, meeting the requirements of FRCP 26b, 2b, and the general duty of good faith in discovery. An incorrect approach that focuses solely on the most readily accessible data sources, such as company-provided email servers, fails to account for the broad definition of discoverable information under FRCP 26b. 1. This oversight could lead to the inadvertent destruction or inaccessibility of critical evidence residing on other platforms like cloud storage, social media, or mobile devices, potentially resulting in spoliation. Another incorrect approach, which involves collecting all data from every conceivable source without prior legal consultation or a defined scope, is overly broad and likely violates the proportionality considerations outlined in FRCP 26b, 2b. This approach can lead to excessive costs and burdens for the producing party, and may also introduce irrelevant or privileged information into the review process, complicating discovery and potentially leading to objections from opposing counsel. A third incorrect approach, which relies on informal or ad hoc data retrieval methods without proper forensic tools or documentation, risks data alteration or corruption. This lack of defensibility can undermine the integrity of the collected evidence, making it inadmissible or subject to challenge under FRCP 37e if the data is lost or damaged. Ethical obligations require a CLTP to ensure the integrity and authenticity of evidence. The professional reasoning process for a CLTP in such a situation should involve 1. Understanding the legal and factual scope of the matter in consultation with legal counsel. 2. Identifying all potential sources of relevant electronic information, considering the nature of the allegations and the roles of individuals involved. 3. Developing a phased collection strategy that prioritizes data sources based on relevance and accessibility while ensuring proportionality. 4. Employing forensically sound methods for data preservation and collection with meticulous documentation. 5. Regularly communicating with legal counsel regarding progress, challenges, and any necessary adjustments to the collection plan. 6. Adhering to all applicable rules of procedure and ethical guidelines regarding electronic discovery.